Hello guys, welcome to the subject Law on Obligations and Contracts. I want you to listen very carefully and attentively in order to understand our discussions. Our subject again is Law on Obligations and Contracts, but we will only be tackling the general provisions part 1 or the chapter 1 on the Law on Obligations and Contracts. If you have noticed, there is written part 1, so meaning we still have part 2 of the general provisions of this lecture video. Please be reminded that this lesson or video is intended only for students taking up Bachelor of Science in Business Administration. It's either major in management, marketing management or financial management, not intended for those students. Our reference material for this lecture is the book of Hector de Leon. We will start by looking at our learning objectives. So we have here the following learning objectives. So number 1, to understand what is civil obligation and why is it a judicial necessity. Number 2, to know and understand the 4 essential requisites of civil obligation. Number 3, to understand the meaning of a right, cause of action, injury, damage, and damages. Number 4, to understand the different sources of obligations and be able to cite examples from each sources. And number 5, to understand what is restitution, reparation, and indemnification. This video contains 4 parts. We have part 1, what is obligation. Part 2, essential requisites of obligations. Part 3, sources of obligations. And part 4, scope of civil liability. So let's get started on the part 1, what is obligation. Okay, part 1. What is obligation? Under Philippine Civil Code Article 1156, obligation is defined as a judicial necessity to give, to do, or not to do. This definition is the legal definition of the civil obligation. So if we will try to understand the meaning of this definition, refers only to civil obligation. So we have heard the following examples of civil obligation. First, simple obligation to pay your tuition fee at school. So if you have to go back to the meaning, we have 3 ways, no, or forms in order to perform the obligation. Alright, so to give, like to pay your tuition fee, that is to give money specifically. Number 2 is to do, like obligation of a parent to take care of their children. And number 3 is not to do, no? Obligation of anyone not to steal. Okay, so if we will recall the definition, there is a word juridical necessity. So it's very important to understand, no? To understand this word. So the word juridical necessity is important, no? In here we can distinguish civil obligation from other type of obligation, because only the civil obligation where you can associate the word juridical necessity. But what is the real meaning of juridical necessity? So we'll be discussing through this line. So let's read. In case of non-compliance, the courts of justice may be called upon to enforce its fulfillment or in default thereof the economic value that it represents. So when we say judicial necessity, a certain obligation, it is required to be fulfilled. Kailangan gawin. Otherwise, you will be sued in the courts of justice or kakasuhan ka. So, it's very clear, no? Kakasuhan ka sa isang court, ang i-enforce ng korte ang fulfillment regarding this specific civil obligation. So, let's go back to the different examples of civil obligations that we have mentioned earlier. Then, what follows are the different obligations. What is being written here? The different obligations, but it's not judicial necessity. Meaning, hindi siya nag-fall under the meaning of civil obligation. So, number one, so your obligation to attend masses. So, yan ay moral obligation. Hindi yan civil obligation. Second, to pay back your debt of gratitude. So, natural obligation yan. So, utang na loob. So, hindi yan nakufall sa civil obligation. Under civil obligation, as we have to recall, pwede mo siyang makasuhan pag hindi mo magampanan yung obligation. So, pag utang na loob, meron kang option. It's either bumawi ka or hindi ka mag-fulfill. Kung hindi ka makabawi, so hindi mo siya pwedeng makasuhan. So this obligation fall under the natural obligation. So let's proceed to the next essential requisites. Okay? So if we say essential requisites, there are parts, no? These are parts obligation that if there is missing in any one of the essential requisites, we cannot say that it is civil obligation. Yan. So we have 4 requisites. So if you have noticed, every requisite there is multiple terms. Every requisite mayroon siyang iba-ibang terms, no? So for example, number 1, passive subject. So passive subject can also be called obligor. The active subject can be called as obligee. So basically these two refer to the persons or parties involved in an obligation. Alright? So number 3 and 4 naman, they do not refer to person. So the number 3, prestation, can also be called object, no? Pwede siyang tawagin subject matter. So we have already placed the different terms na pwede natin i-associate sa specific essential requisite na yan. So this very intended, kasi maraming libro nagagamit ng iba-ibang terms. So we have already mentioned, no, those different terms. So number 4, we have vinculum. Okay, so let's start with passive subject. Okay, so passive subject or obligor refers to person who is bound to the fulfillment of the obligation. Number 2 is the subject subject or obligee is the person who is entitled to demand the fulfillment of the obligation. So for example, if we have utang, no? So, yan ang example natin. Naruto is obliged to pay his income taxes. So, let's analyze the situation. What's the obligation? Sino may obligation? Si Naruto. So, he is the passive subject. Kailangan siyang magbayad ng taxes. So, i-consider natin siya na passive subject. Ngunit, sino naman yung active subject? Although it's not being written here, who is the passive subject? But it is being understood that the person should pay the Philippine government through the BIR. Kasi yung BIR is under the Philippine government. So prestation naman, to give money. Okay? So let's go back to the meaning. Prestation refers to the conduct required to be observed by the debtor. It may consist in giving, doing, or not doing. Okay. So if you try to recall the meaning ng judicial necessity, okay? So, judicial necessity to consist of giving, doing, or not doing, or to give, to do, or not to do. So that is the question that we are referring to. Okay. So let's go back to the example. So the prestation here is to give, no? Specifically to income tax. Normally, nagbabayad tayo ng tax in cash or any method, other mode of method. Pero ang usual na mode of payment is via cash. So next is essential requisite, which is judicial necessity. Okay, we'll go back to the meaning. It binds or connects the parties to the obligation. So sino yung kinoconnect ang parties? So itong dalawa, passive subject and the active subject. So let's go back to the example. Sino ang bind? Itong si Naruto and the Philippine government. So what specific matter that binds them is the law. So we have the tax code, no, that binds the two parties, which is the law, no? It is the tax. Well, if you earn money, let's say you have work, so you are obliged to pay taxes, and that is specifically called income taxes. So Naruto here is the passive subject. The one who has the obligation to pay, while the Philippine government is the active subject. So the one who has the right to demand payment. And 3, the prestation refers to the payment of money to the Philippine government. Okay, so to give. And number 4, the last is judicial tie. So what binds the two parties, the passive and active subject in this case, or in this situation, is the law, specifically our tax code. As a way of analyzing why there is a tie between the passive and active subject, the reason is because of the law. So because of the law, there is obligation. So that is the tax code. Next is another example. So we have contract of sale this time. Okay, we have to read the example. Tanjiro sold a bottle of wine to Inosuke for 1,000. Okay, so as you have noticed, we have prepared a table. So under this table, we have placed the 4 essential requisites. So as you have also noticed, we have 3 columns. Columns number 2 and 3. We have obligation number 1 and obligation number 2. So what's the difference between this second example of ours to the first or previous example? So the first or previous example is what we call unilateral obligation. Unilateral yan. Unilateral obligation. So when we say unilateral obligation, there is only one passive subject, or there is only one party who has the obligation. Whereas in this case, contract of sale, this is not unilateral, but it is called bilateral. So when we say bilateral, there are 2 parties. Okay, so these 2 parties have their own obligations to each other. So ito ang kakaibahan ng dalawa. So as you have noticed here, the passive subject here is Tanjiro. While obligation number 2, there is there is obligation number 2 is inusuki. So we go back to our contract of sale. Tanjiro is ay nagbenta ng bottle of wine to Inusuki. Ang Inusuki naman ay magbayad ng 1,000 pesos because he is the buyer. So there are two obligations here. So if we analyze obligation number 1, the passive subject is Tanjiro and the active subject is Inusuki. If we will recall the meaning of passive and active subject, the passive subject is the one who has the obligation, while the active subject naman is the one who has the right to demand the fulfillment of the obligation of the passive subject. So what is the prestation? In this case, obligation number 1, the prestation is to deliver the bottle of wine. So who has the obligation to deliver the bottle of wine? Naturally, the one who has the obligation to deliver the bottle of wine is, in this case, is Tanjiro because he's the seller. And the one who has the right to demand the delivery of the bottle of wine, in this case, is Inusuki because he is the buyer. So next, let's proceed to the obligation number 2. Excuse me. In obligation number 2, on the other hand, nabaliktad yung ating mga parties. So yung our former passive subject becomes the active subject. And our active subject becomes the passive subject this time. So in our obligation number 2, our passive subject is Inusuki. So if you recall, Inusuki is the buyer, while Tanjiro is our seller. So the prestation obligation number 2 is to pay 1,000 pesos. So let's analyze. The one who has the obligation to pay is Inusuki. So we consider him as the passive subject. Excuse me. And the party who has the right to demand the 1,000 pesos is Tanjiro, which is the seller. So we consider him in this case as the active subject. So as you have noticed, both obligations have juridical time. So which is the contract. So they are bound because of the contract. So if you recall the juridical tie, this is what binds the two parties, the passive and active subject. So that we can easily remember, let's try to think, what's the reason that binds the two parties? So simple. It is because they have contract. So in this case, the contract of sale. Okay, so let's proceed to the next. Okay, so let us define these terms: obligations, right, cause of action, or wrong. So we illustrate these different terms. So let's try to. Obligation is a judicial necessity to give, to do, or not to do. So again, this to remind that this definition refers only to civil obligations. Next is right. Actually, if there is an obligation, there is a corresponding right. That's always, no? If there is an obligation, there is a corresponding right. So what is right? Right is the power which a person has under the law to demand from another in any prestation. So let's go back to the example. Tanjiro has the obligation which is to deliver the bottle of wine. But there is also a corresponding right on the part of Inusuki to demand from Tanjiro the delivery of the bottle of wine. So let's go back. Next is the cause of action. Okay? So when the cause of action arises when there is act or omission which violates a right. So when we say act, this refers to act being forbidden for him to do. No? So yung bawal. While omission naman, this refers to not performance, to the not performance of an act which is he is bound to do, which resulted to the cause of action. So Pag omission, hindi ka pwedeng mag-act pero nag-act ka. Okay? So the definition of cause of action refers to act or omission which violates a right. So later on, we will illustrate some more to understand these terms. Then we have injury, damage, and damages. So we have noticed there is a difference between damage and damages. Yung mayroong S at walang S. But we'll start from the word injury. Injury is the act or omission which causes harm. Damage naman is the harm done to a party. While damages, sum of money recoverable by reason of damage done. So in this slide, I will explain or illustrate so you will understand now. Let's try to go back to the example between Tanjiro and Inosuke. We have the contract of sales between the two. So in the table, we can see the obligations and rights. Under the obligations, Tanjiro is to deliver the bottle of wine. And Inosuke naman is to pay the 1,000 pesos. Under the rights naman, Tanjiro has the right to demand collection of 1,000 pesos. And Inosuke has the right to demand delivery of the bottle of wine. So in other words, pag right to demand certain prestation po siya. Okay? So, if Tanjiro deliver the bottle of wine, so the new term here is right of action. So, if we'll try to recall the definition of civil obligation, it is a judicial necessity. What is again the meaning of judicial necessity? So, meaning, necessary siya. So, kailangan siyang gawin or i-fulfill ng passive subject. Ng passive subject po natin. Dahil kung hindi si active, meron po siyang right of action. Okay? So, right of action meaning the commencement of filing a case against a certain party. Okay? So, under judicial necessity, pwede siyang kasuhan. No? So sino mang hindi mag-fulfill ng kanyang civil obligation, pwede siyang kakasuhan. So, ipafile mo yung kaso sa isang korte. Siyempre, the court, no? Of course, will act, no? And we will wait for the court, no? To decide with regard kung anong isasampang kaso against a certain party. Excuse. So, in this case, Tanjiro is the one who can file a case against Inosuke. So, si Inosuke kasi is the violator. So, ano yung binayolate niya? Binayolate niya yung right ni Tanjiro, which is the right to demand the collection of 1,000 pesos. So, yung hindi niya nagawa is yung pagbayad. No? So, next. Once kinasuhan ni Tanjiro si Inosuke sa isang korte, Tanjiro is called the plaintiff. Okay? So, while Inosuke naman is called the defendant. So, let's analyze the case. What is the cause of action? So, don't be confused with the meaning of the cause of action and the meaning of the right of action. The right of action is attributable to the active subject, meaning the plaintiff. Here in this case is Tanjiro. Whereas cause of action, meaning the cause which resulted to the cause of action on the part of Tanjiro in this case. So, cause of action and right of action, kumbaga, magkasunod lang siya. na pangyayari. Once there is cause of action, there will be right of action on the part of one party. So cause of action is the omission on the part of Inosuke in this case, which is specifically not paying the 1,000 pesos na supposedly matatanggap ni Tanjiro dahil nagkaroon ng pintahan na dineliver naman niya ang bato na buwan. Yun nga lang, Inosuke did not fulfill his obligation. Hindi siya nagbayad. So next is damage and damages. So you might be thinking that damages is the plural form of damage. So let's try to see. Damage, Tanjiro incurred loss on the sale. So tama naman, naka-incurred siya ng loss. Damage can be or cannot be quantified. In this case, ma-quantify siya kasi simple lang naman ang case natin. But there are examples na hindi siya ma-quantify. Damages refers to sum of money recoverable by plaintiff in terms of money. Here, 1,000 pesos plus. Why 1,000 pesos plus? Okay? So, damages pwedeng ma-recover na plaintiff. So, in this example, 1,000 pesos plus. Why there is 1,000 pesos plus? Why there is plus? Because normally, when the court issued a decision, let's say the decision is favorable to the plaintiff or Tanjiro because the evidence is overwhelming against Inosuke and in favor for Tanjiro, normally, the award or grant ng money recoverable for Tanjiro is more than 1,000 pesos because aside from the 1,000 incurred damage at Tanjiro, there are still other damages that Tanjiro could still recover, like moral damages and others, no? So like moral damages and others. So in other words, 1,000 is just a minimum, no, na ma-recover. So there are other pwedeng ma-recover ng nananalo. Okay? May mga gastos rin kasi kapag kakasuhan mo yung isang party in the court. Normally, it is included in the award for the plaintiff. So, let's say you have incurred another 1,000 just to initiate your action. That 1,000 will be included by the court in the award of damages. So, normally, 1,000 is the minimum in this case. Again, what's the difference between damage and damages? So damage is the amount incurred by the plaintiff, while damages is the sum of money recoverable from the defendant. That's the difference between the two. It is not the plural form, no? Na yung walang S. So that's the difference between the two. So we must always remember, no? So next, proceed to the next types of obligations according to prestation naman tayo. So according to this slide, we divide real obligation. We divide obligation to real and personal obligation. This is real to give, where personal obligation is positive and negative. Or when we say positive, to do, and negative naman is not to do. Then next tayo is sources of obligation. So Article 1157. So according to Article 1157, obligations arise from law, contracts, quasi-contracts, acts or omissions punished by law, and quasi-delicts. So before we proceed, we'll just to emphasize the 3, 4, and 5. These 3, although the, in this article 1157 mention about 5 sources of obligation, but these last 3 are sources from law. No, sources from law. Why? So basically we can only have 2 sources, no? Law and contracts. Yung contracts po kasi specifically mayroong provisions ng contract. Pero yung specific contracts na pwedeng buuin na mga parties ay hindi natin yan maisa-isa or mailista sa isang batas na ma-enumerate natin lahat. So basically we have only 2 obligations arising from law and obligations arising from contracts. But of course, we should not forget the number 3, 4, and 5. Still, they are considered under the law. So, but I'd like to be clear that this number 3, 4, 5 are still considered under the law because there is a specific provision of our law referring to number 3, number 4, and number 5. So these 3, 4, and 5, these are under still the law because mayroong specific provisions under the law. Tungkol dito number 3, 4, and 5. So next, let's start with obligations arising from law. Our obligations that arise from law are explicitly mentioned by law. So when imposed by the law itself, for example, pay taxes. Okay? So why we pay taxes? Because it is specifically required by law. So that is the tax code. Okay? That is our law. Then obligations of parents to the family, that is under the family code po yan. Okay? So the source of the obligation here is still the law. Okay? Under the family code. Okay, next we'll proceed to the obligations arising from contracts. But before we'll tackle on that, let's define first what is contract. So a contract is a meeting of minds between 2 persons whereby one binds himself with respect to the other to give something or to render some service. So if you can recall, we have an example earlier, a contract of sales. So under the contract of sales, we have 2 parties and they have meeting of minds with regards to kung ano yung ibibinta nila at kung magkano. Okay? So yun. Or to give something or to render some service. Nagpo-full yun. Example natin under the definition of contract. So to give the example earlier, okay, a contract need not necessarily be in writing. Okay, so you might also be thinking that a contract is what is being signed by the persons. That is one form of a contract only, but a contract will still exist even without written document. For example, you and your friend agree that he will borrow your calculator, let's say 5 days, and after 5 days he will return the calculator to you. So you have formed a simple contract. Specifically, that contract is a contract of comodatum, but we will not discuss the contract of comodatum. Next, the third source of obligation. This is the obligation arising from quasi-contracts. So nandun pa rin yung root word na contracts. But if you try to recall a contract, there is meeting of minds. Okay? Ibig sabihin, magkasundo. But in this case, there is a different definition. So, tingnan natin. So, ang quasi-contract is a judicial necessity, a judicial relation resulting from certain lawful, voluntary, and unilateral act by virtue of which the parties become bound to each other to the end that no one will be unjustly enriched or benefited at the expense of another. So let's start with the word, no? Unilateral. So, unilateral act. So, if we'll go back to the definition of contract, we can consider the contract is a bilateral act. No? Yung contract, we consider that as bilateral act. While why there is bilateral act, meaning the two persons that we are referring to earlier, they have certain act to perform. Okay? So, for example, earlier, the contract of sale. So, if you can still recall, Tanjiro binds himself to perform an act, which is to deliver the bottle of wine. While Inosuke, on the other hand, also binds himself to perform an act, which is to pay the bottle of wine delivered to him. So in this case, this contract is a bilateral act. While here, in quasi-contract, okay, if we'll go back, it is unilateral act. Unilateral act, meaning the obligations that arise from quasi-contract are not necessarily contract, although there is a word contract. That's why there is a word quasi or quasi. If you say quasi or quasi, as if contract. So there is a word as if. So then we'll emphasize also the term, no one will be unjustly enriched or benefited at the expense of another. So that you will understand, I have to show more examples. Okay, number one, you receive excessive change after buying from a store. So excessive meaning sobra. So it is your obligation to return the excessive change. Okay, so this is an example of solutio indemnity. Okay, quasi-contract. So sino yung obligation? Ikaw, naka-receive ng excessive change sa sobrang sukli. So if you analyze, there is no contract in the first place. Na nagsasabi o nag-usap ba kayo ng store owner, nagbibinta, na kapag sobra ang na-receive mong sukli, kailangan mong ibalik. Siyempre wala namang usapan. So in the first place, hindi naman alam na magkamali ang tindera na ibigay sa iyo is sobrang sukli. So hindi po ito contract. Pero even there is no contract, you can still have obligation because of this quasi-contract that we are referring to. So the core principle of this quasi-contract is that what I mentioned earlier, no one would be unjustly enriched at the expense of another. So let's analyze the situation. So if you receive the excessive change, you benefited, right? But that benefit is unjust or di makatarungan. Kasi wala kang kahirap-hirap na naka-receive ng pera. Although maliit lang yun, pero naka-receive ka pa rin ng pera. Pero kanino yung expense? Expense po ni store owner or ng tindera. So, you are obliged to return the money because those core principle. So notice, there is a word solutio indemnity. So this specific example is solutio indemnity. Okay, so another example. Another person took care of your dog while you're away. it is your obligation to reimburse him the necessary expenses he incurred. Okay? So this sample is under the negosyo, negosyorum issue. So you're obliged to reimburse the expenses incurred, no? Your neighbor in feeding the dog. Anyway, you benefited in the first place since your dog is still alive. But whose expense? Expense of your neighbor. Okay? So this specific example is negosyorum issue. So pag pinapakain mo yung aso, no, kahit walang permiso ng may-ari, so of course you have incurred an expenses or gumastos ka. So pagbalik ng owner, so you are entitled to receive the reimbursement of the expenses which you have incurred. Okay? Kahit walang permiso. That is under the quasi-contract. Okay? And it belongs to negosyorum issue. Okay? So, under this principle pa rin, no? That no one shall be unjustly enriched at the expense of another. Okay? That's all. That is the core principle of this quasi-contract. No one is unjustly enriched or benefited at the expense of another. Then, aside from this, meron pang ibang quasi-contracts. But we have to tackle that in the next video na lang. Okay? Next, we'll proceed to what is called obligations arising from delicts. So what are these delicts? So let's go back. Okay, yung term, yung list yan. So acts or omissions punishable by law. So parehas lang po yan ng quasi-delict. So let's go back to delict, no? Also known as crime or felony. So that's the other term for delict. So in this case, you will encounter such terms like crime or felony. They're the same as delicts. Okay? It is said, unlike other sources of obligation, delicts produce both criminal and civil liabilities. So civil liabilities means a case filed in court, and once the decision of the court is against you, then you are required to pay damages. So you are required to pay damages. While criminal liability naman is the penalty of which is imprisonment. So hindi po lahat na obligation will result to imprisonment. So the obligation arising from delict, those are obligations if not fulfilled. Pag hindi po magampanan, there is a tendency that you will get imprisoned. Okay? So here, this delict, specifically the criminal liability, will not be discussed thoroughly in these obligations, no, and contracts, because our obligations and contracts specifically refers only to civil liability. Okay? So yung civil code where the obligation and contracts belongs. Okay? So yung obligation and contracts natin nasa 1156 onwards, but ang civil code nag-umpisa siya sa Article 1. Okay, under the civil code nandyan yung mga other topics such as law and partnerships, nandyan yung contract of sales and contracts of lease, etc. So marami pong under the civil code. Pag sinabi natin criminal liability, normally hindi siya sakop ng civil code. Yun ay sakop na tinatawag natin na penal code. Penal code. Okay. So, ano ba example ng mga obligations arising from delicts? Staffa or rape. Okay? So, doing these crimes could get you in prison. Imprisonment. So, criminal liability yan. Mayroong criminal liability. Okay, next. Here we have the last source obligations. Obligation rising from quasi-delicts or quasi-delicts. So here, the root word is delict. But hindi siya, it's not the same as delict because delict, iba yun. Because there is criminal liability. Whereas in quasi-delict, there is no criminal liability because the concept being associated here is the so-called negligence. Negligence. So, what is negligence? Negligence means kapabayaan in Tagalog. Okay? So, the other terms here also known as tort or culpa. So, this is an act or omission by one party causes damage to another party wherein there is no pre-existing contract. So that we can understand, we have to go to our examples. Number one, because of the organizer's negligence, audience were hurt during an event. Okay? Number two naman, because you're not careful, babayaan pa rin, while running in a busy sidewalk, you bump into a child and the child suffered injuries. So, sinabi dito, in good cases, the tortfeasor or kumbaga yung nakagawa, nagkaroon ng obligation dahil may kapabayaan sa iyong ginawa. So, yun ang term tortfeasor. So, in this case, organizers. So, ikaw will answer for the medical expenses or the audience first and the child second case. So, dito sa dalawa example natin. So, bakit? Why you are obliged? Because of your negligence. Okay? So, even though there is no contract between the organizers and the audience, it is still binding, no? Both of them. So, kahit walang contract, magkaroon pa rin siya ng binding, no? Binding force. And the binding force is the so-called quasi-delict. So, the reason there is the negligence. Although there is no contract between the organizers and the audience, which says that in case the audience will be hurt because of the negligence of the organizers, so it requires that they will answer the medical expenses of the audience. So there is no such contract in the first place, but even if there is no contract, there is still obligation on the part of the organizer once it will be proved that there is negligence. So the same in example number 2, you are not careful while running in a busy sidewalk, you bump into a child and he suffered injuries, then you are liable for his medical expenses because there is element of negligence again. So our keyword again in quasi-delict is the negligence or kapabayaan. But normally, it will not result to criminal liability. But there are rare cases that our quasi-delict will result to criminal liability. So it's a quite complicated topic. Okay? So I will not expand here. Okay, so we'll proceed to the next. To the fourth part of the lesson is the scope of civil liabilities. Okay? So nandyan, 1, 2, and 3, restitution, reparation, and indemnification. So, yung mga meaning, kinuha natin yan sa civil code. Pero para mas maintindihan natin, punta muna tayo sa example. Dito, okay, example, Gel stole the vehicle of Senko. Gel was cited by the authority and was engaged in a car chase. After a while, Gel was apprehended by the authority, but the vehicle he stole from Senko got damaged. Furthermore, Cinco should have presented the vehicle in a car show the same day Gel stole the said vehicle. As a result, Cinco lost potential income from car show. So, what happened here? The car of Cinco was stolen. But what happened? The authority apprehended Gel, the one who stole the car of Cinco. But only the car was damaged due to intense car chase. Okay? So it was also said the car should have been presented by Cinco in a car show in the same day, which supposedly gave him income but was lost since it was stolen. Okay? So, kung ito, baga si Gel nagnakaw, si Cinco nanakawan. Okay? So, let's go back for example. Under restitution, the restitution of the thing itself must be made whenever possible with allowance for any deterioration or diminution of value as determined by the court. So, in example, or in this situation, ang restitution po is the return of the vehicle. No? So, restitution, pwede pa naman ma-return ang vehicle because nandun pa siya, hindi pa siya na-loss. Na-damage nga lang. But if the car got worse, sumabog yung kotse, so wala na. Here, in this restitution, instead of returning the specific car, the one to be returned by Ken, ang nagnanakaw is the monetary value of the car. So, the fair value normally. So again, in restitution, it comprises the return of the thing. But if not possible to return the thing stolen, the one to be returned is the monetary value of the thing stolen. So let's analyze. If it's not possible to return the vehicle, let's say sumabog yung vehicle na yan, whose possible ba ang second scope natin, which is reparation. So reparation is to answer for the damage caused to the vehicle. So reparation kasi, let's read. The answer for the damage caused to the vehicle. Okay? So reparation for damage caused. Okay? Court shall determine the amount of damage taking into consideration the price of the thing when possible and its special sentimental value to the injured party, and reparation shall be made accordingly. Okay, so the meaning of reparation is you are required. Meaning of reparation is you are required to restore. No? O restore the original state of the things stolen. So bago mo siya nanakaw, kung ano yung state niya, no, original state niya, ganun din ang pagbalik mo. So in reparation, hindi possible ang reparation if the thing itself is already lost, since it's no longer possible to restore the original state of the thing lost. Okay? So, but the exception, if we'll go back the definition, reparation, there is the so-called special sentimental value. Okay? So, maybe, yun na lang ang ma-recover. Okay? So, reparation, sandan yung tinatawag natin na special sentimental value. So, yun na lang ang pwede ma-recover. So, for example, yung kotse, nanakaw ni Gel. So, in this case, pwede pa siya ma-restore. But if pag sumabog na, hindi na pwede hindi na siya pwede maibalik sa dati. Okay? So, let's say yung kotse na yun is pamana pa, inherited pa. So, in this case, mayroon siyang sentimental value. So, yung sentimental value, pwede siyang mag-assign si court ng specific value. So, tinatawag natin na sentimental value. So, yung sentimental value is under pa rin siya ng tinatawag natin reparation. So, reparation is still possible if the thing has sentimental value, even the thing is damaged beyond repair, or it can no longer restore its original state. So that is separation. So generally, reparation is not possible if the thing is totally lost. Okay? So let's proceed to the last, which is indemnification. So ano sinabing ng indemnification? Okay, let's go back to the situation. Nandun. So, Cinco supposedly to attend the car show, no? So his car maybe is a vintage, so he will present his car, and he was supposedly to earn income, but because it was stolen, so the one who stole is Gen. So Gen is required to pay indemnification. So the amount which Cinco is supposed to earn should be paid by Gen. For example, the amount to be earned is 50,000 pesos. So included in the civil liability po siya to be paid by Gen. Okay? So si Gen is to indemnify. Babayaran. Si Gen is to indemnify Cinco for the loss. Okay? Let's say the amount lost by Cinco is 50,000 or 100,000, as it depends sa amount, then he will receive that amount. Okay. So hindi siya totally na-destroy, possible pa mabalik sa original state, pero gastos na Gen. And lastly is indemnification. So this is the consequential damages. So what's the consequence? The consequence is for not Cinco to present, for failure of Cinco to present. So therefore, there is restitution, return of the car, pay repairs, and pay Cinco 50,000, for example, in this case, plus, aside from civil liabilities, Gen will also face criminal liability. Okay? So that's the last part, which is the scope of civil liability. So there we already finished in part 1 and general provisions. Okay, so thank you very much for listening. Okay, so next will be the part 2 of the general provisions. So I hope that you will listen to our next lecture. Thank you very much. Bye bye.